Well, we have heard from Judge Gull in the Delphi murder case and what her thoughts are on how everything has been transpiring from the closed door meetings to the dismissal of the attorneys of Richard Allen, and someone who's been following this extremely closely from the beginning, Bob Motta, defense attorney. Thank you for joining us. Bob, what's your take on all of the documents that have recently dropped from Judge Gull's response and where this is all headed now?
Oh man. I mean, it seems like we say this like every time we chat that it's like the case that never sleeps. Like
Mhm.
I just never I've needed like it's just constant filings with this thing. So as you stated, we did get the response. We got two responses actually yesterday, the attorney general and then Gull. I was obviously more interested in seeing Gull's, but it was funny because the attorney general's response actually dropped first. So I was like, wow, this is interesting. I'm like, did the attorney general decide to step in here?
Mhm.
And like, because we had heard originally that the attorney general wasn't going to respond
Yeah.
on behalf of the judge. So I was a little taken back by that. And I'm like halfway reading through that thing, and I get an email that Gull's response had dropped.
Yeah.
So drop the AG's thing, jump right into Gull's thing, start reading through it. And, I mean, it's as far as her position as to the merits, and there's two primary arguments there. The first argument, um, which frankly, if the Supreme Court is going to go by the law, she'll probably win it. And
Mhm.
and that which will mean because she's saying that procedurally that there's a something they call a condition precedent, meaning that in order for them to have gone to the Supreme Court of Indiana, that what they should have done, what they're required to do, is that they have to do what's called an interlocutory appeal.
Okay.
Okay, so that they have to go try to appeal the decision regarding her not allowing them to enter their pro bono appearances on the 31st of October because that was essentially the day that they were removed. I know that everybody likes to talk about the 19th when she claims that they both withdrew, and it's questionable whether or not Rosie did it all. He clearly did not. He didn't do it orally, and he didn't file a motion. So it was like I guess a de facto withdrawal, but it wasn't by the book by any stretch.
Sure.
So, for all intents and purposes, I still thought he was in the case. So I've always considered 1031 to be the day where they entered their pro bono appearances and she looked at Richard Allen and said, sorry, in good conscience, I can't allow these two guys to continue on as your defense attorneys. I think they're both incompetent and I think that they've been grossly negligent with the representation of you. So that's kind of the issue, the germane issue. So, what the argument that they made primarily, her and her attorney, is that procedurally they have to file that interlocutory appeal at the appellate court level, get denied by them, and then, and only then, if that remedy, if you've exhausted all your other outlets, all your other potential ways to get a remedy, which in this case would be an interlocutory appeal. Now, there's some question of whether or not that issue in particular of whether or not she had the ability to be able to deny them entering their appearance can even be brought up in an interlocutory appeal. But for the purposes of filing it and getting denied, it doesn't matter if it's getting denied if the appellate court's like, we don't handle this issue.
Mhm.
Like that would have been sufficient because then that means that the last resort is going up to SCOIN, going up to the Supreme Court of
Yep.
Indiana.
Yep.
And so that would have taken away that argument from them. And anytime you're reading a document like that, and I did a YouTube live on it. I always do when they drop documents, which
Yeah.
our listeners should probably check out if they're wanting to get the nuts and bolts of these documents. I really, Allison and I do real deep dives on them. Typically read the whole thing, but you know, i- in that case, it would have removed that initial argument. Which, again, in that type of a document, you're always going to have your most powerful argument first. So that's what she led with. So if the Supreme Court decides that they agree that they did have a remedy, that the remedy should have been to go to the appellate court first, get denied there, and then come to us, they can deny it without getting to the merits, which is all the stuff that we've been talking about, all the, the leak, and does that stuff reach gross negligence? Was there due process? Like all those issues, which are the merits of the case, the Supreme Court doesn't have to decide any of that because they're saying we can't even get to the merits because it's defective. Your pleading was defective procedurally. So unfortunately, we're dismissing it because it's procedurally defective. And now we don't have to answer any of that stuff.
Mhm.
Have a nice day. So, and we talked about it last week, man. The politics of it. I mean, it could, if they follow the law and they don't buy the argument, because like Kara Weineke, who was one of the primary drafters of that second original action, I had her on our YouTube, and like after she had filed,
Yeah.
and I asked her flat out, I'm like, what do you think your chances are? Because they had to make the argument. They knew that rule. You know what I mean? That they didn't just skip the appellate court willy-nilly, not understanding the law. They understood it, and they put their reasoning and why they skipped that step in their argument.
Mhm.
So the Supreme Court, if they find that to be compelling, that relief really wasn't available to them, that the interlocutory appeal was not available to them, then they might survive that portion. If they survive that portion, then we get to the meat, then we get to the good stuff, and we'll see where they come down on it. But Karen, like when I asked Kara, she was like, I don't know. Like they just don't grant writs like this very often. It really is an extraordinary relief. And it doesn't happen very often. So I wouldn't have called her like overly optimistic. You know what I mean? I think that she felt, um, I wouldn't even say she was guardedly optimistic. I'd say she was a bit pessimistic, but realist. I mean, she understands it's like it's a tough thing to get the Supreme Court to do, especially no matter what we think of Judge Gull's performance on this particular case. She's been on the bench a long time. I think up until this point, she's been pretty well respected. And, she's made 3 different attempts to get on the Supreme Court herself. So, I mean, and these are fellow judges. Yes, they're at a higher level, but they're also, part of the judiciary, and they sit on the bench. I don't know that they'll be like chomping at the bit to blast one of their colleagues. You know what I mean? So I think that there's a very high likelihood that if they can find an easy way out,
Mhm.
where they don't have to even get to the merits, where they don't have to say, Gull, you screwed this up,
Yeah.
where they can say, look, you didn't follow the rules here. You should have filed the interlocutory appeal. And by way of that, we're dismissing the matter. And then they're in the clear. I think they might take it. That's
Yeah.
just what my gut's telling me. I hope it doesn't play out that way because I really think that it's important that these 2 guys finish this case out for a lot of different reasons.
Yeah.
But like the least of which being that I want them to finish it for their own good. The most of which being I want them to finish it because that's who the defendant wants as his attorneys.
Sure.
It's his Sixth Amendment rights. It's his constitutional rights that are at stake.
Yeah.
So yeah, so that was my initial blush on that thing.
So what does this mean then for Richard Allen going forward and the case itself with the way that what Judge Gull has argued, which I get it. If we're going just to the letter of the law, it makes some sense what their argument is. But at the
Right.
same point, there's a lot of things that do need to be dissected here and dealt with. Is this just punting it down the road at some point where it's going to be brought up in some other way, shape, and form? Or does this pretty much, say we don't need to argue any of this? We don't need to bring you any sort of resolution to these.
Well, interestingly, if they get to the merits, okay.
Mhm.
So say they agree with uh the relator, Kara and Richard, in terms of their argument as to why they had to skip that step. Say let's just pretend that the Supreme Court lets them survive that defective aspect of it
Yeah.
and say, okay, we find that this is an extraordinary circumstance. We're going to allow you to skip that step because we think in the totality of the circumstances that it's called for here.
Mhm.
And we get to the merits and say we get to the merits, which is again, was there due process? Was the fact that they had multiple conversations about this possible DQ leading up into the 19th that they should have known and they should have been prepared, and that they find that that's sufficient, or that they find that the judge it was within her discretion to be able to remove them, and that that these particular findings that she made without an evidentiary hearing were sufficient, and that it was within her purview to be able to take them off the case or not allow them to enter their appearances. If that's the case and they rule on it, that is done.
Mhm.
Like, he cannot then take a second bite of the apple if he gets convicted and say, man, I got completely screwed because I lost my lawyers at the beginning of the case.
Yeah.
And she put on two guys from her home turf who she knows she's going to be able to control, who in no way, shape, or form are going to be able to prepare for trial in a timely fashion, and more likely than not are going to abandon the defense that I want to put forth. Like, but he's done. Like,
Yeah.
so you almost have to hope that they do lose it here, because I'd rather have that. But see, the problem is once you get convicted, getting things overturned on appeal, but that right to counsel,
Mhm.
it's almost like an automatic remand.
Yeah.
That is the one thing, like, because remember, it moved out from where they had been appointed, because the Supreme Court, has started to change its tune in terms of appointed attorneys like public defenders, where it's always been that you have no say so. Like,
Mhm.
you don't have the money. It's inequitable when you like start thinking about it, that
Sure.
people with money, obviously the Sixth Amendment applies to them, but people that are broke who have to have public defenders, it doesn't apply to them. The Sixth Amendment, your right to counsel. So like you can't just do like a bunch of attorney shopping. If like the judge appoints you a public defender, you're like, man, this guy sucks. I don't want this guy as my lawyer. You realize that, like, after meeting with him once, or the guy never calls you, or the gal, whatever the case may be,
Yeah.
and you're like, man, this lawyer's not doing any work. I want a new lawyer. You can't go to the judge and say that. It's like you just can't like cherry pick your lawyers when they're appointed. And so the Supreme Court has always said that. And then the argument becomes this continuity argument.
Mhm.
Like, for instance, these guys had been working on the case for a year,
Mhm.
had about 1,000 hours into it, and they had created a true attorney-client bond.
Yeah.
So it had changed from just a regular appointment of a regular PD to these guys were handling it as if they were private counsel, and they really were. But that all went away as soon as these two guys entered their pro bono appearances. It then became counsel of choice.
Mhm.
So like that issue, frankly, would allow, I think, Rick Allen to get a new trial if he gets convicted just on that alone.
Yeah.
So it's almost better for him if you think it out, like, all the
Long,
way.
long way. Yeah.
It's a long, long way, for the Supreme Court to just go through, deny it on the procedural thing, have it get kicked back. Because what I think will happen, Tony, is if these two guys don't get reinstated, I believe that another lawyer will step up,
Mhm.
another private counsel will step up and enter his appearance pro se. I really do. I
Mhm.
think it's that type of case.
Yeah.
And like, people can think whatever they want about, oh, well, the attorney's just doing it for the publicity. Well, maybe, but who
But if
cares?
they can
If
do a
they're
better
if
job, why not? Yeah. If you're
exactly
Richard Allen,
right. I
you
mean,
don't care at that moment.
right. And like, why should an attorney have to go in and do a massive amount of work for free?
Sure.
Like I have no problem with an attorney if he's going to get publicity and he does a good job, and especially if Richard Allen's innocent,
Yeah.
which Baldwin and Rosie are like lying on the sword saying that he's innocent. Like,
Mhm.
this isn't like the typical lawyer defense thing. Oh, my guy's innocent of the crime. This is like they're adamant
Yeah.
that this guy is innocent. They truly believe that he's innocent. I mean,
Sure.
that's why they're putting up this fight.
Mhm.
I mean, you have to know, and I can tell you from doing it for 20 years, I always, always zealously represent my clients. Always, always. But if I had a client that I came to find out after I got all the discovery that was actually innocent, like didn't commit the crime,
Yeah.
I would be fighting just like this to stay on the case to fight.
Sure.
It's like, whereas if I got all the discovery and it looks like they pretty much got my guy dead to rights with the evidence,
Mhm.
and I know that any competent attorney is going to be able to go in there, make sure he gets a fair trial, make sure he understands the process,
Mhm.
do their jobs, represent them zealously, make sure the cops did their jobs right. Like a majority of attorneys can do that are competent. But when you get a situation where you think that the guy's actually innocent, it changes things. And like
Yeah.
the way that they're fighting to stay into this tells me that it's not that other situation, because otherwise they'd be like, all right, man, we put up the fight. I'm sure these other two attorneys are fine attorneys. They can handle it. They got the evidence. They're going to get him anyway.
Yeah.
You know what I mean? It's like they know what the evidence in the case is against Allen,
Yeah.
and they know what they've seen. They know what they've read. So, yeah, I mean, we'll see how it shakes out. But like at the end of the day, like I said, I think if ultimately they don't prevail and they're not reinstated the case, I think that there will be another attorney that will ride in on a
Mhm.
on a big giant stallion with a big
Yeah.
constitutional shield, saying, I'm coming in to take the case over." And Allen will, of course, opt to go with this, because I'm sure it would be a high profile guy
Sure.
that would come in on a case like this. And he'll take over the defense of it. Like I don't think he's going to end up with Scremin and Labredo no
Mhm.
matter what.
Yeah.
Like that's a scary proposition. And again, both of those guys might be very capable attorneys, but the circumstances under which they've been appointed leave me very uneasy about
Sure.
the whole thing. Like they're not who Allen wants, but beyond that, they appear to be home picked guys for Gull.
Yeah.
And and I have a very long thought on why she actually did this, and it has nothing to do with the leak in and of itself. I think
Mhm.
that she used the leak and the other things as to why she ultimately booted these guys from the case. But what I really believe, and if you've ever tried a case, you'd understand that coming into like the 12th, 13th of October, when they're going back and forth, when the leak thing happens, and Rosie told the judge, I think it was in an email or in a phone conversation, that look, we are going to be ready to go to trial in January. Like we're going to be filing our speedy demand, which means, if for those folks out there that don't understand what a speedy trial demand is it's if you're in custody or out of custody, when you make a demand, it's got to be, it varies from state to state, but it's got to be by that date.
Mhm.
So the date from which he was arrested to January 8th was going to fall within the time in which they had to bring him to trial. And it's ironclad.
Mhm.
There is no, the state can't come in and say, we need a continuance. We're not ready to go to, it's too bad.
Yeah.
You have to go to trial, or the case against Richard Allen gets dismissed if they don't start trial
Mhm.
on the date before the speedy date runs. So
Yeah.
it's a drop dead date. So I believe that when he told her that, and she knew in her mind, and the state knew in its mind, Nick McClelland's mind, and this is before McClelland had any help. Like I kept walking in there and I'm looking at Nick McClelland sitting alone at counsel's table, and I'm like, where's this dude's help? Like, you cannot try a case like this alone. You need a trial partner on this thing. If for anything, just to help you getting through the documents, to break up the cross examinations and directs, you need to split the work because it's too much for one lawyer to do. And on that date, up until that point, McClelland was alone. There was no way that he was going to be ready to go to trial January 8th. There's no way.
Sure.
I mean, would he have had to have gone? Yes, he would have. Would he have been properly prepared? There's no way in hell.
Yeah.
He couldn't be. It's just too much work. It's like people don't understand. It's like lawyers just aren't winging it, walking into court at trial. Oh, I'm going to ask this guy a bunch of questions. No, man, it's like a massive amount of work.
Yeah.
And beyond that, it's like all of the motion work would have had to have been done prior to that trial date. in 2 months, in terms of a trial looming, you remember how, like, when you were back in school and, like, you would take a test, and you remember how time moved differently?
Mhm.
Like, if it was kind of a test that was you were struggling with,
Sure.
and it was gonna take the entire period, and whether it was math, if you struggle with math, like me, I struggle with math, hence the law school, but, like, that time moves faster.
Yeah.
Like, time just moves much quicker in those situations. So multiply that by 50 when you're talking about 2 months period when you're trying to prepare for a trial like this, where you've got to do all of your pleadings, file all of your motions or responses to motions. You have to get all of your witnesses ready. You have to find experts, get them ready, have them do reports. You've got to get them prepared for trial. You've got to prep them for their testimony. You've got to do everything, everything. You've got to prepare all your cross examinations
Mhm.
for all the state's witnesses, and the state has to prepare all the crosses for who they think the defense is good. It's like the amount of work involved is 24 hours a day for 2 months straight is like not nearly enough time
Mhm.
to get it done. So, and for Gull, that would have meant that she was going to have to work every day through the holidays, every day, that they would have to be preparing the motions. They'd have to be arguing the motions because she doesn't get to choose what motions he gets to file and what he doesn't. If they file it, she has to set it for a hearing, and
Sure.
there has to be a hearing. And that means that she's got to be in there for every court date that she sets these hearings. And she hadn't even finished reading the memo and hadn't even begun to review the 1,500 items of discovery that were attached as exhibits, meaning that she was a long way away from having even that done, and they still were going to probably file motions to quash the arrest, motions to suppress, because we had one motion to suppress, which was for the Franks hearing, was leading into the motion to
Yeah.
suppress the search of Richard Allen's home, but they were going to still try to keep the ballistics out, or the tool markings, the
Mhm.
unspent casing. Yeah, there was a ton to be litigated, and she would have had to work through all the holidays. The only day she would have had off was Christmas Day, and I think that infuriated her. I really do, and I think that she believed that Nick McClelland wasn't going to be ready for trial either, and that she used this, the leak is a scapegoat
Yeah.
for her getting rid of these two guys, man. I mean, like, if I were able to, like, she'll never admit that, but you can just look at it, and if you have an understanding of what the speedy trial is, and that it is a unforgiving deadline, that means they have to be ready. The state must be ready. They must proceed on that date, or it's over. And I think that with that pressing date, and I have no reason to believe that these guys were bluffing. Like, I've heard people out there say, "Oh, they were just bluffing." I don't think so. I think that they were ready to go.
Yeah.
And the advantage from the defense side of it, that's part of the strategery.
Mhm.
I like to use that fake word
Strategery,
because it's
yes.
great.
Seinfeld,
But
right? Yeah.
it's
Yeah.
like, I know if I'm making my clients making a speedy demand, that is putting a huge amount of pressure on the state to get their case ready way before they typically have it ready,
Mhm.
which puts them at a disadvantage. Sometimes, but it also puts the defense at a disadvantage because you're under the same time constraints. The
Sure.
difference being, they had two guys and they had a bunch of people in their office that were working this case, where it was Nick McClelland alone trying to prepare. Now he's got another guy. He just brought on a guy on October 31st, this Luttrell guy. So he's got some help now, but still at that point, that guy was having to play catch up anyway. So the judge got exactly what she wanted. She kicked this trial date to October of next year. She just bought all kinds of time. So
Yeah.
I don't
It's
know, man.
just
It's a mess. The
so
whole thing's a mess.
twisted, and at the end of the day, it's Richard Allen, innocent or guilty. One shouldn't be treated this way. One shouldn't have to go through this kind of, torture, basically, of being locked up the way that he is. There's just so many
In a
elements to this
prison,
that
man.
just point to corruption in Delphi, and it's all out there in the open. And there's not seem a lot of recourse really to tamper any of it down. It's just gonna, it's like the
I
speeding train
mean,
that's just gonna go where it's gonna go until it finally goes off the rails or comes to its stop.
Yeah, I for real though. Like, and it's like that feeling of like helplessness in this country, you
Mhm.
know,
Yeah.
with the Constitution in place firmly is should be upsetting to everybody.
Yeah.
I mean, I've said it on your show many, many times. I mean, Abby and Libby only get justice if he's the right guy
Exactly. Yeah.
and if he gets a fair trial.
Yeah.
I mean, if he is the right guy and they have all the evidence and they
Great.
have to sit through a trial and they screwed up this Sixth Amendment thing and the families have to sit through a second trial for what all
Yeah.
intents and purposes would be a foregone conclusion
Yeah.
is a nightmare for the family.
Yeah.
And if it's the wrong guy and it's not the correct person or persons,
Yeah.
it's not only a nightmare for the families because they put all their trust in law enforcement and the prosecution when they've said this is the guy, we're confident of it.
Mhm.
And knowing that they knew all this stuff the defense is talking about, like that's the thing about this case.
Mhm.
Like this case, you've got the Saudi thing out there. Some
Yeah.
other dude did it, defense, and we know who they are. And we know that there were other cops that were investigating these guys for months after the Unified Command, who was the little task force they put together that was really investigating. When they abandoned that 3 weeks in, that whole Odinism or these guys being involved, and they're like, nah, we're
Yeah.
not buying it. Sounds crazy. It's like when the family, like, I mean, the family's hearing the same thing that we are. You know what I mean? And the family, they have their own minds.
Yeah.
So when they've got the prosecution and law enforcement saying this is the guy, this is the guy, this is the guy,
Yeah.
but they're hearing this other stuff and they're hearing everything else that's going around in the community. I mean, it's a very small community.
Mhm.
They can't be feeling good now, like about
No.
what is going on procedurally or from the investigation side of it. I just can't imagine that they're feeling super confident that they've got the right guy in there. So yeah, man, it's not a good look, that's for certain. I mean, I'm frankly, I'm doing everything I can from the sidelines
Yeah.
here as a former defense counsel and a member of the defense bar. I've offered support in many different ways to Kara, who's been handling because I'm not even talking about the innocence or guilt part of this.
Yeah.
Like, I'm not even there mentally.
Just
Like,
right and
I
wrong.
don't know what they have. Right,
Yeah.
right. I mean,
Yeah.
I'm just talking procedurally. Like,
Yeah.
this is screwed up.
Yeah.
It's just not how the system's built to work. And the judge has gone off the rails with this one, and that's just my personal opinion. I mean, from the sidelines, and it's scary. I mean, I always just think of it. Try to put yourself in somebody else's shoes, and imagine, God forbid, that the cops knocked on your door, said, "Hey, Tony, you know what, man? We are arresting you for the murder of some little girl that lives down the block
Mhm.
because we saw your car driving by 6 times like that day. And, we think we have enough evidence and we're throwing you in prison and and then you get some lawyers on and they're working really hard. And then the judge says, you know what? I'm not going to allow those guys to be your lawyer anymore. I'm going to pick a couple lawyers for you. I mean, dude, that prospect of that is just terrifying,
It
you
is.
know? I
And if
mean,
it yeah.
and if it turns out that this dude is legitimately innocent, people are going to have to really take a long look in the mirror
Mhm.
at like the system and like how this thing went down
Mhm.
and how scary that is.
Yeah.
Because if it can happen to him, if
Yeah.
he is in fact innocent, it can happen to anybody.
Yeah.
This guy had no background, family man, put his daughter through college, never had been arrested for anything, no proof of him being a creep of any kind. Like
Yeah.
there's
Nothing
nothing
adds
about
up.
this guy that fits
No.
other than that he offered, volunteered the information that he was at the bridge. He put himself there.
Yeah.
People are like, oh, yeah, he's trying to get ahead of it. I don't think so.
No.
I've never heard of murderers putting themselves at the crime scene
Yeah.
like voluntarily,
Yeah.
not during an interrogation.
Yeah.
Guys cave during interrogations all the time. This isn't that. It's different.
No.
So I don't know, man. Yeah, the
No.
case is like a total rabbit hole for me.
Another total train wreck to look on, and we'll have to see what happens next
Yeah,
as the
for sure.
drama continues. Hey, it's Tony Brueski. If you want more of our interview with our guests, be sure to check out our podcast, Hidden Killers with Tony Brueski. Just search that wherever you download podcasts and press subscribe. Also, you can check out our YouTube channel for the full video version of the interviews as well, under the same name, Hidden Killers with Tony Brueski. Check it out, subscribe, binge, and enjoy. Thanks for watching.